Good evening. This is environmental law, and tonight I'll be dealing with Chapter 5 of Bates' publication, Environmental Law in Australia. Tonight's talk is in relation to federal governance and environmental protection. Obviously, Australia is a federation of 6 states and 2 territories, and that's created through the Commonwealth Constitution. And it's from the Commonwealth Constitution that the power for the Commonwealth to make laws is provided. And in that regard, we're familiar with Section 51. You would have recalled from previous talks that there is no direct legislative power conferred upon the Commonwealth to make laws in relation to the environment. Quite frankly, as Bates points out, that wasn't an issue that was under consideration at the time that the powers were being considered. Environmental law is such a new subject. At 5.2 on page 130, Bates says that in general it may be said that the states can legislate on all matters not specifically. G'day Laurie, how are you doing?
Good, how are you?
Good, thanks.
Good. That's good.
In general terms, the states can legislate on all matters not specifically referred to in the Constitution. In other words, the Commonwealth doesn't have exclusive jurisdiction in relation to most of its powers, but where it does, it's referred to in Section 52 of the Constitution, and also Section 90, which gives power to deal with most environmental issues concurrently, rather than at one level or the other. So Section 90 deals with levies of customs and excise. So tonight, what I want to do is talk to you firstly in relation to the Commonwealth Powers, which caters for pages 130 through to 155 inclusive, State Powers, which is 155 to 171, and then specifically the Environment Protection and Biodiversity Conservation Act, which is covered in pages 171 through to 183. So firstly, Part A, dealing with the Commonwealth legislative power in respect of the environment. And this is at Bates 5.30. Commonwealth powers to make laws are set out in Constitution Section 51. And if you have a look at that section, you'll see a number of heads of power. And as we've identified, if that conflicts with state powers, then the Commonwealth will prevail. And that's Section 109. At 5.6, which is on 133, Bates says that the ability of the Commonwealth to rely upon the enumerated powers to attract its authority and impose conditions has been actively challenged in the High Court on a number of occasions. There was a plethora of cases in the 1980s and 1990s in relation to state versus Commonwealth. So those matters have been actively challenged in the High Court during that period of time. And as a result, statutes have been particular to carefully express themselves as relying on one of the wide range of powers referred to in Section 51 to ensure that, as far as possible, there is not another challenge to that legislation. In other words, federal legislation frequently hedges its bets by referring to not just one head of power, but a number of heads of power upon which the Commonwealth has the power to legislate. And from the Commonwealth's point of view, the ability to rely on a wide range of powers in fending off these constitutional challenges means that while from the state's point of view, the irony is that the environmental issues have served to enable the High Court to define or refine the extent of the Commonwealth powers in favour of the Commonwealth, thereby upsetting the long-held notion that environmental issues relies primarily with the states. In other words, what Bates is saying is that the Commonwealth is setting up 2 sets of defences. The first is that when it does enact laws, it will try to specifically refer to the head of power in the Constitution. And the second is that where the states have taken them on, the issue has generally been held in favour of the Commonwealth, and the extent of power which the states had thought they had have been eroded as a result of those decisions in the High Court. So as a result of that, whereas previously the states had been taking on the Commonwealth fairly regularly, they're now much more collectively reticent to do so. So at 5.7 at the tail end, Bates says that realisation and recognition of the extent of Commonwealth power to legislate on environmental issues undoubtedly provides a solid basis of power upon which it may enter into and conduct negotiations with the states on national environmental policy. In other words, the Commonwealth's power is becoming much more obvious and used. So what are these heads of power? And Bates identifies a number. The first is the trade and commerce power, which is section 51(1). So the Commonwealth has power to make laws in relation to trade and commerce with other countries and among the states. The case referred to there is the important decision of Murphy-Oars against the Commonwealth. It was 1976, 136 CLR. CLR means Commonwealth Law Reports, which means it's a High Court decision. And in that case, the High Court upheld the Commonwealth's decision to refuse to grant export approval for mineral sands from Fraser Island, and that was done on environmental and social grounds. So that's an important decision which showed that environmental laws and environmental executive decisions can be made by the Commonwealth even though it does not specifically have an environmental power conferred upon it. In that case, it relied upon the trade and commerce power. Likewise, we have the external powers or external affairs powers, where, unlike other countries, international treaties are not ratified by the Commonwealth Parliament, but rather by the Commonwealth Government. The effect is that Australia takes on international obligations under a treaty. However, ratification has no direct effect on domestic law within Australia. So the Commonwealth Government ratifies the treaties which are made by the Commonwealth. The case which is referred to there, again an important decision, the Tasmanian Dam case, Commonwealth against Tasmania 1983, and in that case the High Court determined that the Commonwealth may validly enact domestic legislation in relation to external affairs if the subject matter of the legislation is of international concern. So once again we see how the Commonwealth have used the head of power that they do have, in this case external affairs, to enact legislation which is ostensibly environmental in nature. I'll refer you through to page 139, where midway through at the tail end of 5.13, Bates says, in the Tasmanian Dam case, the whole of section 9 of the repealed Act, except for two parts, was struck out by the High Court because it purported to prohibit specific activities which it would not necessarily which it would not be necessary in all cases to prohibit in order to achieve the objectives of the treaty. Such blanket prohibitions could not be justified. So the High Court did put the brakes on the Commonwealth by ensuring that if it is going to enact legislation, trying to use various heads of power, it must do so selectively, and it can't use blanket prohibitions in terms of its use. The third power, which is referred to in Bates, is the corporations power, and that is section 51, subsection 20. You'll note that's in Roman numerals, where the Commonwealth is empowered to legislate with respect to foreign corporations and trading or financial corporations. And at 5.17, it is clear since the Tasmanian Dam case that the power under 51.20 or XX is not confined to regulating the trading activities of trading corporations. Non-trading activities may also be regulated. At 518, the scope of this power is therefore very significant, as later to become just as Wilcox pointed out, the list is almost endless. Another commentator, Zines, agreed, the clear result of the case is that the Commonwealth may regulate and control all acts of trading and financial corporations done for the purpose of trade. So that is an extensive power which the Commonwealth can in some instances use to deal with environmental issues. The fourth power, which has been identified by Bates, is financial powers. That's at 5.21, where the Commonwealth enjoys a number of powers relating to financial issues which may be used for the purpose of promoting environmental measures. Now, in that context, Bates makes reference to special purposes grants and taxation and federal spending powers. I'm just going to highlight one thing which is mentioned at 5.24, and this is under the heading of taxation, where, of course, the Commonwealth now does have power to use the carbon pricing mechanism, which was introduced in the Clean Energy Act of 2011, referred to commonly as the carbon tax, as a tax by reason of the initial price of a unit of carbon being set by the Commonwealth and then moving in 2015 to emissions trading schemes that will be dictated by market forces. So that's a hybrid tax which is introduced in that legislation, and I stress that because I believe it's likely to become a more readily and more extensively adopted means of dealing with environmental issues through the trading schemes. Now, moving on from that, I'm just going to highlight, and I think this is important, 5.32, which is the Commonwealth's power, or perhaps more rightly stated, obligation, to acquire property on just terms. And the Commonwealth Parliament has power to make laws with respect to acquisition of property for any purpose which it has power to make laws, although such an acquisition must be on just terms, which is 51 Roman 31. In other words, compensation must be paid if property is acquired, and that compensation must be on just terms. The case decided Newcrest Mining against the Commonwealth from 1997. It was a High Court decision, and the High Court remarked that this provision was a protection against arbitrary and uncompensated deprivation of property. We discussed the concept of property back in Chapter 3, particularly in relation to the distinction between property rights and permissive rights such as licenses. The law must affect property rights. There must be an acquisition, not just a mere sterilisation, extinguishment, deprivation, modification or restriction. The law must be categorised as one with respect to the acquisition of property, and lastly, it must provide for just terms. It is, however, difficult to identify what is meant by the term property. It's not as straightforward as one might think. As indicated earlier, in Chapter 3, we talked about the distinction between property and permissive rights such as licenses. But if we look at the decision of the Commonwealth against WMC Resources, which is over the page, you'll see that the respondent in that case was granted a statutory permit to explore for petroleum in a certain area, which was the subject of a dispute between Australia and Indonesia. That dispute was eventually settled, and the Petroleum Act of 1990 was enacted. The provisions of the Act effectively abrogated rights of exploration which had been conferred by earlier permit. So the High Court had to determine whether the claim by WMC was compensable as a result of that changed circumstance, that changed paradigm, if you like. And in that case, the High Court interpreted the conferment of a permit as conferring a right of property that had subsequently been extinguished. In the decision, Justice Kirby said, amongst other things, few corporations engaged in the chancy business of petroleum exploration at sea would invest the large amount of capital required if, upon discovery of petroleum, the government grantors would simply thank the venturers for their efforts and either retain the benefits for themselves or assign those benefits to others. So the detriment which was suffered by the company in that case and generally has been identified by the High Court as being relevant. So the detriment suffered is relevant in those circumstances. At 5.33, we must counter that, however, with the comments that are made there. So compensation is only payable if property is acquired, and extinguished or sterilisation of a right of property does not necessarily amount to an acquisition. The case there, Mutual Pools against the Commonwealth, and in that case, two of the justices remarked that to constitute an acquisition there must be an obtaining of at least some identifiable benefit or advantage. Now that makes a lot of sense because that's consistent with the discussions that we had from Chapter 3. But mere sterilisation of a particular land use does not necessarily amount to an acquisition. In the Commonwealth against WMC, the case we talked about before, the property right conferred by the permitting arrangements described arose out of a statutory scheme. Such rights would be capable of effecting an acquisition if transferred to a third party. However, the provisions of the legislation extinguishing such rights did not in this case. If we look over at page 151, Bates quotes from the decision and says, "The statutory modification or extinguishment of a permit or an interest in a permit is not an acquisition of property by the Commonwealth, for the Commonwealth has no liability reciprocated to the permit or interest and acquires no benefit by the modification or the extinguishment." So again, if we look at Commonwealth against the Tasmania, 1983, Tasmania argued that because the Commonwealth had passed legislation forbidding the construction of the hydroelectric dam, the Commonwealth had thereby acquired property. The High Court rejected that argument, pointing out that sterilisation of this particular form of land use did not thereby prohibit other uses to which the property might be put. However, if we look at Newcrest Mining against the Commonwealth, the effective termination of a right to mine was considered to be an acquisition of property. If we move down, there is comments that although this case has been criticised, it is nevertheless consistent with the finding in Tasmanian Dam. In Newcrest, there was no other form of land use open that the plaintiff could, following sterilisation of that particular form of land, use. Effectively, therefore, the Commonwealth had acquired the property, the benefit passing to the Commonwealth. So I think that's the key issue there, and the way in which we can distinguish the apparent conflict between what the High Court is saying in Newcrest and what was said earlier in Tasmanian Dam. The concept of whether there was any other form of land use open following the actions by the Commonwealth government in both, or by the government in both instances. At 5.35, an argument has arisen in relation to 5131 that could be triggered if the Commonwealth financial assistance legislation subsequently is used to enable a state government to acquire property other than on just terms. And some commentary made there. Just over the page at 5.36, there's some reference there to the special purposes grants, which you might read at your leisure. So I've stopped and emphasised that point. Now that might be something that you can assume as being important for examination purposes, and I've made reference there to the whole concept of acquiring property, the basis upon which Commonwealth and state governments can acquire property, and if so, how and when can a party affected be compensated and what are the rules for the compensation. The key issue there, the first point is you've got to identify whether in fact property has been acquired, and it's not necessarily easy to do so. All right, well that's what I propose to say in relation to the Commonwealth, the federal power, in relation to environmental issues. Before I move on, are there any questions? I'm looking at the chats. Nobody wants to come online. All right. That being the case, let's move on to the state legislative powers in respect of the environment. This is from page 155 through to 171. Bates says, the states retain the lawmaking power they enjoyed at the time of federation to legislate for the peace, order and good government, subject only to the limitations imposed in the Constitution. So we've been through this a few times, but there are 4 limitations on state legislative power which are identified by Bates. That is section 52, where there is exclusive jurisdiction in relation to Commonwealth places and the Commonwealth Public Service. Section 90, where the Commonwealth has exclusive power in relation to customs, duties and excise. Section 92, which means that trade within the Commonwealth must be free. And finally, section 109, where in the event of a conflict, the Commonwealth law will prevail. So Bates then goes on to make comments in relation to those 4 matters which provide limitations imposed by the Constitution on state lawmaking ability. He starts with the second of the 4 that he's identified, which is the Constitution, section 90, which deals with exclusive power to make laws in relation to customs, duties and excise. And Bates comments at 540, the state's ability to pursue environmental goals through taxation measures is significantly restricted by section 90 of the Constitution, which prohibits the states from raising taxes by way of excise. And excise is was described as an embracing all taxes on, in respect of, or a step in the production, manufacture, sale or distribution of goods. Now just over on the other page, states can provide financial incentives for environmentally friendly behaviour within the limits of their own revenue-raising powers. Provision of economic or market-based incentive schemes for environmentally responsible behaviour is becoming one of the cornerstones to the modern approach of sustainable environmental management. The market-based instruments which give effect to that are referred to in Bates at 6.40, chapter 6.40. All right, so that's the first of the limitations, which is section 90. The second limitation is in section 92 of the Constitution, which is that there is a guaranteed freedom of interstate trade and commerce. That does not mean, however, that no interstate trade may ever be restricted for environmental purposes. The first of the issues that Bates raised was to do with Commonwealth places, and that's section 52 of the Constitution. That's referred to at 546 onwards. And Bates says that the only laws that may be validly enacted in respect of Commonwealth places are federal laws. State environmental and planning laws do not apply to Commonwealth places unless Commonwealth legislation expressly provides for such applications. So what that means, of course, from a practical point of view, is that if you're looking at places such as airports, you need only look at Commonwealth legislation as opposed to the state legislation which would apply elsewhere. At 5.48, the Commonwealth Places Application of Laws Act from 1970 provides for the application of state laws to Commonwealth places, but not generally, including environmental and protection and planning laws. So in other words, the Commonwealth can let the state laws in if they choose, but that particular legislation from 1970 does not generally include environmental protection and planning laws at a state level. Bates goes on to say that state laws that attempt to restrict or control Commonwealth activities are ousted by section 4.3. Application of criminal laws are not necessarily restrictive of the place as opposed to the conduct on it. Now, the fourth restriction is section 109 of the Constitution, where at 5.49, Bates says, the Commonwealth can avoid the application of state laws by operation of the Constitution, section 109, which provides that to an extent of inconsistency between federal and state Commonwealth will prevail. Well, we know that. A good example of the operation is seen through the conflict in Tasmania over the Gordon below Franklin power scheme. The the Tasmanian Parliament authorised work to begin. The site which was chosen was in an area of national and World Heritage significance. The Federal Labor Government enacted the World Heritage Properties Conservation Act of 1983 and passed regulations in relation to the Act, effectively prohibiting construction work without the consent of the appropriate federal minister. And the High Court in that case upheld the validity of the Commonwealth Act. Commonwealth law will often affect discrete areas of an activity rather than to attempt to take over the whole of the activity. So in that instance, areas where both Commonwealth and state laws can apply in harmony. Commonwealth legislation may make it clear. For example, the EPBCA Act expressly declares that the Act is not intended to exclude or limit the concurrent application or operation of laws of a state. But sometimes, however, the clear intent of the Commonwealth is to cover the field. And if the Commonwealth does intend to cover the field, as it were, then the state laws can be ousted in those circumstances. It was held that the environmental assessment provisions of the Environment Planning and Assessment Act 1979 in New South Wales did not apply to the Federal Airports Corporation. That's just an example that we talked about before as well. I'm just going to move you forward to 5.53 rather, which is the implied neighbourhood power or nationhood power. The High Court has developed a doctrine of implied immunity of the Commonwealth from state laws. Commonwealth immunities from state laws are not as broad as once thought, and there's an example there in relation to residential tenancies. So that was the implied nationhood power. There is some reference to the COAG agreement, and the immunity of the Commonwealth from state environmental laws has been a major source of conflict between Commonwealth and states. In 1997, the Council of Australian Governments drew up the draft agreement, and that contains, amongst other things, a commitment by the Commonwealth to subject itself to state environmental laws. However, this commitment will only apply to Commonwealth Government departments, agencies and authorities which are required by the Commonwealth to comply or elect to comply. So COAG, in that sense, is fairly limited. It essentially is only applicable where the Commonwealth directs that its own departments must comply or the departments choose to comply. Cooperative federalism. Now this is referred to at 5.55, where comments are made that the recognition flowing from decisions of the High Court in the 80s that Commonwealth powers in relation to environment may well be more extensive than previously realised has led the federal government to suggest and the states to acknowledge that a cooperative approach to environmental issues might be more politically expedient. So what we say is, in the 80s and the 90s, the states were taking on the Commonwealth. They were regularly being beaten, and the High Court was effectively expanding the power that the Commonwealth had And now, in recognition, perhaps a détente, if you like, there is now a more cooperative approach. And it's not politically good, either at a state or federal level, for the governments to be spending a lot of time and effort, resources and money in having these disputes in the High Court settled. So now there's more a cooperative approach. In the interest of both state and federal governments, therefore, they try to work out cooperative solutions to environmental problems wherever possible. There's reference here to a statement made by the then Premier of New South Wales, Mr. Greiner, who in 1990 said, "I firmly believe that we must reconsider our narrow obsession with state rights." The Premier was, however, careful to point out that the Commonwealth had to assume corresponding financial responsibility. Queensland and the Commonwealth fought bitterly over the introduction of native vegetation clearance controls, Queensland demanding that the Commonwealth compensate landowners who were denied clearing rights. The Commonwealth equally adamant that it was Queensland responsibility, and the coming into force of the Vegetation Management Act of 1999 was consequently delayed while those funding compensation issues were sorted out. There's reference to national policies and strategies and comments made that the impact of the different approaches adopted in the 90s is most noticeably marked not only by the absence of constitutional legal challenges, but also by the cooperative development of national strategies. And over the page at 558, the development of national strategies suffers from various criticisms which are outlined, but they do have some advantages which are also outlined. The next topic at 5.60 is ministerial councils, and consultative processes between Commonwealth and states are formalised through ministerial councils, standing committees of senior officers, and specialist and ad hoc committees of various kinds. I've talked about COAG, and that is the forum where the Prime Minister and state and territory premiers meet to discuss national issues and determine national policies. And ministerial councils are generally comprised of state and federal ministers. And over on 169, Bates says that as a cooperative and information sharing arrangement, these ministerial councils have great potential to formulate and secure the adoption of long-term and wide-ranging national environmental policies. All of this, I think, goes back to some comments that were made right at the start, that environmental law is really very young. It's new. And we had this period of time through the 80s and 90s where there was a lot of butting of heads, if I can use that term, between the Commonwealth and the states. There was a recognition that environmental laws must come into effect. Environmental management must be maintained. There was a lot of early conflict, if you like, to determine where the boundaries should be set between the Commonwealth and the state. Now there's this much greater emphasis on cooperation, and that surely is for the benefit of everyone concerned. All right, so that's a brief overview of Commonwealth powers and, if you like, contrasting state powers, and the conclusion now that there's a cooperative arrangement wherever possible between the two. I'd like to finish tonight's session with some comments in relation to the Environment Protection and Biodiversity Conservation Act, 1999, Commonwealth Act, of course, and this is from pages 171 to 183 of Bates. The EPBCA is the outcome of a decade of debate about what might be the appropriate Commonwealth's legitimate legal role in environmental protection. So until we had all those disputes resolved in the High Court, there was really no scope for introducing legislation such as EPBCA, and the obvious reason is that the Commonwealth has no power on its face to make any laws in relation to the environment at all. So to have a law which is Commonwealth and has the word environment in it is on its face quite a strange thing, but when we look at the historical context, it makes sense. So at 568, EPBCA concentrates on those matters of national environmental significance which were flagged by the COAG Agreement of 1997, and that includes World Heritage Properties, Ramsar wetlands, nationally threatened species, migratory species, nuclear actions, Great Barrier Reef, and so on. It also applies for all actions on Commonwealth land. So EPBCA does not have blanket application to environmental issues in Australia, only those where it has power through the Constitution and agreement to do so. So at 5.69, outside Commonwealth land and marine areas, the Commonwealth will only be interested in actions that might affect matters of national environmental significance or that are conducted by Commonwealth agencies. Land clearing, for example, is inescapably linked to the loss of biodiversity, salinity and water quality, issues that are recognised by all Australian governments as of immediate and significant national concern. At 5.70, there's comments in relation to actions, and the processes under the Act are triggered by certain types of actions. An action is defined as including a project, a development, an undertaking, an activity, or an alteration of any of these, and that's section 523 of the EPBCA. You're going to see consistent reference to actions in the commentaries, and you may need to come back to this paragraph a number of times just to clarify what is an action. So an action is a project, a development, an undertaking, an activity, or an alteration of these. Over the page at 571, the scheme of the EPBCA, actions which, if undertaken without approval, would be prohibited are known as controlled actions. A person must not take a controlled action unless approved. Prohibited actions are those which would be or likely have significant impacts on matters of national environmental significance. So the test of significant impact is the key to determining the question whether an action is a controlled action, and this task is entrusted to the Minister. At 5.72, the comment made that the Minister must determine whether the action is a controlled action and which actions are controlling provisions. If the action is determined to be a controlled action, relevant impacts, including past, future and probable impacts, must be assessed by one of the methods laid down in the Act. And then there's some comments made in relation to when those actions need not obtain approval. Okay, so we're getting close to the end of tonight's commentaries, but there's some notes there about bilateral agreements, which is an agreement concluded between the Commonwealth and a state or states or territories. And the purpose of the agreement is generally minimise duplication of environmental assessment and approval processes. And in a few weeks' time, we'll be talking about environmental assessments and those processes both at a state and Commonwealth level. And I'm hoping we'll have a guest speaker for that as well. And finally, I'll draw your attention to 5.81, which deals with criteria for decision-making under the Act. In deciding whether or not to approve the taking of an action and what conditions to attach to an approval, the Minister must consider matters relevant to the matter protected by a controlling provision for the action, and also social and economic matters. That's section 136 of the Act. In making a wide range of decisions, the Minister is also instructed to take into account the precautionary principle to the extent that he or she can do so consistently with other provisions of the Act. And you'll recall that the precautionary principle we talked about before is something which is gaining greater emphasis in international law as being relevant for consideration in environmental issues. So always look very carefully at anything that involves the precautionary principle. All right, well, that's all I propose to talk about tonight. You've been very patient in listening to me. I next week will raise some other issues which are referred to in the commentaries, and I'll put on Moodle as well. So before I sign off, just checking if there's any questions on the chat screen. No. Does anyone wish to raise any questions or make any comments? All right. Thank you very much. I'll stop recording now. Thank you.